I'm really trying not to get into the weeds on it, but I have to. The next one is Aguirre-Zuniga v. Garland, and I just find it so interesting because, first of all, I believe this is the first decision written by Judge Jackson Akuumi, and I hope I said that right. And Judge Jackson Akuumi was on the short list of Supreme Court appointees to replace Justice Breyer. She didn't get picked, but she was on the short list. And so I think this is her first immigration decision now that she's not going to make it to the Supreme Court. And what she said was that Indiana's definition of meth is broader than the federal definition of meth because it criminalizes possession of more isomers. And I don't even know what an isomer is. It's like a chemical stuff. It's his whole argument that federal public defenders and immigration practitioners have been making forever. The Ninth Circuit picked it up like 4 years ago, and then they
having this, learning what the hell this was.
And then they depublished their decision. So, and it's been rejected in the 5th and the 11th recently, but for different reasons. I would argue that it's still alive and well in the 11th, depending, just to create a different factual record. But either way, the 7th Circuit completely on board. Indiana's definition of meth, at least its old definition of meth, I think it might have changed now, covers more isomers, statutory text, the analysis that this Supreme Court loves, that the Federalist Society loves, and it's broader than the federal definition of meth. That's the end of story. There is no realistic probability test. More isomers, federal definition of meth that makes it broader than a controlled substance is an offense, and that's the end of it. And there's a lot of analysis that gets into it, but the 7th Circuit has agreed with the isomer argument, which is very applicable to both cocaine and meth, and God knows what else drugs. Mm-hmm. There was an 11th Circuit decision argued by Michael Vastine and Sui Chung many months ago, which they of course did a great job because they're at the forefront of these type of arguments, in which the 11th Circuit said, it seems to me, we hear you, your argument might be right, but you haven't proven to us that actually this isomer exists. Mm-hmm. So if you're coming at it in different circuits, that you're at the removal defense stage, I would say submit an expert report from a scientist explaining to the court what these isomers are. But other than that, you have a published 7th Circuit decision, an ambiguous 11th Circuit decision, and then we're not going to do this 5th Circuit decision, but we're in. 7th Circuit, isomers, big decision. It's, again, Aguirre-Zuniga v. Garland. 7th Circuit, yeah.
Does that mean people can now do appeals in that jurisdiction, in that circuit, challenging their cases and stuff like that? Or,
I mean, if the case is pending before an immigration judge or the board, I mean, floodgates opened. If it has already been decided, it's a motion to reopen, and then there's a whole series of law about, changes in case law are not so fundamental that they require reopening. You're essentially asking the board to do sua sponte, or the IJ to reopen sua sponte. It gets more complicated. We do those motions all the time, and there's other good Supreme Court case law that would indicate that in situations like this, the court must reopen, but it does get a bit more complicated. Certainly not automatic. Mm-hmm. I can only imagine oil might try to get cert before the Supreme Court on it too, if there's not a petition pending already.